that's who we are as individuals. I should say the meeting is being recorded from this point on, and we will try and make it available afterwards if you want to review it at your leisure. That's personal introductions. In terms of institutional introductions, we are here today from the Law Commission. I think many of you, most of you, will have a bit of an idea of who the Law Commission is, but just by way of recap, we're a statutory independent body with responsibility for law reform. So that, in very broad terms, is about trying to make the law better in an apolitical way. We are given an area of law, we choose an area of law that is in need of change. We focus on that area for a year or more, and we make recommendations about how it could be made better. And that's exactly what we've been doing with disabled children's social care law over the last year or so. So starting in around September, October 2023, we commenced our review of the law on social care for disabled children. It's something we've been asked to do by the Department for Education. So although we're independent, we work closely with government to ensure that our projects have a reasonable chance of being implemented. And they asked us to carry out the review following recommendations that were made by Josh McAllister, now Josh McAllister MP, in the independent review of social care. So that was a very broad review, looked at the entirety of social care, didn't focus specifically on disabled children, but did look at that area and noted the complexity of the area, noted the fact that parents were concerned that they were often treated through or viewed through what is referred to as a safeguarding lens when they ask for help for their children. And that there's a lot of local variation. There's something about postcode lottery and service provision. So all of those things came together to culminate in Josh McAllister recommending the Law Commission look at this area of law, and that's exactly what we're doing. The stage we're at the moment is the consultation. We published our consultation document on the 8th of October alongside a variety of accessible formats, easy read, summary, whatever you need to get to grips with what we are proposing. And we're asking for people to respond to the consultation by the 20th of January, so in 2 weeks today. And the purpose of today's session really is twofold. Like, firstly, I want everybody to come away with a reasonable understanding of what it is we're proposing and why, so that you're informed and can go and respond to the consultation if you have the time to do that. But particularly for those of you who don't have the time and capacity to do that, we're using today as a way to gather your views so you can provide your comments and thoughts on our proposals within this session. And as I say, although we won't get to every question, if you leave a comment in the chat, for example, we will take it away and look at it afterwards. So that's all by way of context, which gives you a bit of a flavour of what we're doing, who we are, why we're doing it. But coming to the substantial part of the session, I wanted to start taking you through some of our key proposals and questions. So I'll take you through the first half of those before handing over to my colleague Alex to bring them home. And I'm going to start with the point where our consultation paper ends. We make lots of proposals in our consultation paper about how the law could be made better. And the culmination of those questions is, and of those proposals, is a suggestion that in order to accommodate all the changes we think are needed, we need an entirely new legal framework. So I'm going to start there because I think it's an important proposal, but I also have found that it's one of the most difficult and potentially divisive questions we're asking in this context. So when we talk about a new legal framework, we're talking about taking disabled children out of Section 17 of the Children Act 1989, which is where the law currently places them as one type of child in need, and putting them in a separate piece of legislation which is focused on the social care needs that arise from their disabilities. So something a bit closer to the model we have for adults under the Care Act, which is a single law that is focused on meeting their care and support needs. So there's a few different catalysts that underpin that. The first is just that the law is far too complicated. We talk about disabled children's social care law, but really there is no such thing in terms of a single piece of legislation. It doesn't exist. What we have is a piecemeal of different bits of legislation, primary, secondary, regulations, guidance, decisions of the courts that have amassed since 1970 that altogether make for a really complicated framework. So it's very difficult either for a parent or for a social worker or a professional in a local authority just to go to one place and find out this is what the law is, this is what I need to do, this is what my child is entitled to. There is also no one single set of guidance the main guidance in this area is the working together to safeguard children guidance. It's a fairly weighty piece of guidance, but it is not specifically focused on disability. So we think having a new legal framework would make things much simpler, would make it easier for local authorities to do their jobs, would make it easier for families to know what they're entitled to. And that would be a pretty important first step to disabled children getting the support that they need. But that's not the only reason we are making this proposal. The other reason that we are advocating this course of action is the point that I've already referred to in the context of the independent review of social care, and it's the complaint that is fairly long standing that the families of disabled children make, that when they ask for help for their disabled children, they are often viewed through a safeguarding lens. They are often treated as if they are doing something wrong, as if their child's needs arise from failings on the parents' part rather than the child's disability. And the focus is on safeguarding and child protection, sometimes at the expense of identifying and meeting the needs arising from disability. So the common examples that we've heard a lot over the last year is parents asking for help for their disabled child and finding themselves surprised when the child is interviewed on their own in the absence of the parents, when the child's bedroom is inspected, when perhaps fridges are looked in. These are actions that are more consistent with safeguarding and child protection than necessarily trying to provide help to meet the additional needs of disabled children. So that's part of the rationale for us saying, well, we need a new legal framework that is focused on meeting needs rather than safeguarding. The existing legal safeguards for safeguarding, we're not proposing to get rid of those or change them in any way. So Section 47 of the Children Act 1989, which allows for child protection investigation where there's evidence of risk of harm or abuse to the child, that would still apply, but meeting the needs of disabled children would sit within a separate piece of legislation. So that is a provisional proposal that we make. And I say it's divisive because on the one hand, what we are told by many families is exactly what I've relayed to you, which is they're worried that there is too much focus on safeguarding, not enough on meeting needs. For many, this is stigmatizing, it's difficult, it puts some people off asking for help in the first place. But the flip side of that, which we hear from some local authorities, some social workers, is that they need to be critical when they are helping disabled children, because disabled children face different risks to other children, and it's important that social workers do not miss those risks. They're also concerned that if we take disabled children out of Section 17 and deal with them in a separate legal framework, then we might make it harder to identify the wider needs of disabled children. So a child who's disabled might have other needs that relate, for example, to poverty or that relate to their immigration status. So if we take disabled children out, are we segregating them and making it harder for social services to view them holistically? Another concern that's been raised with us by local authorities is that before the Children Act 1989 came into force in the mid to late 80s, social care for disabled children was viewed as a second-class profession, and disabled children themselves were viewed as second-class citizens. And some with long institutional memories worry that if we try and go back to a situation where disabled children are dealt with separately, maybe we won't be treating them with the value that they require, that they deserve, in keeping with the way that they were historically treated. So this is a really difficult one for us. We've put it in terms of a provisional proposal. This is what we think should happen, but we are very alive to the fact that there's a balance to be struck here, and there's important arguments that we need to hear on both sides. So that's what we're looking to hear from you in relation to this overarching proposal, that all of the changes we make should take place within a new legal framework. Coming to the detail, coming to some of the specifics of the different changes we think should be made, I'll start with assessments. When it comes to a child accessing help from their local authority, the first thing that needs to take place is an assessment of their needs to work out what help it is they actually need. And there's a few problems that we've encountered over the last year or so when we've been talking to local authorities, when we're talking to the courts, when we're talking to families. And the first is that the assessment duties aren't particularly clear. There is already a duty to assess the social care needs of a disabled child, but it's not written down clearly in the legislation. It's something that's been implied into the law by the courts, and not everybody knows that it is there. Not everybody knows that all disabled children have the right to an assessment. Um, and one of the consequences of that, as we see it, is that assessments aren't always done when they should be. So we hear, for example, that in the EHCP context, in the context of special educational needs and disability, when an assessment is carried out to see whether a child needs an education, health and care plan, a social care assessment should be a component of that. But that doesn't always happen. We also hear from parents who are meeting their child's needs but are struggling to do so, that often they ask for assessments or they need assessments. So that doesn't happen because the perception is if the parent is meeting the child's needs, then an assessment isn't necessary, which isn't quite what the law says. So what we think might help is to make it clearer what the law is and to write down in legislation that there should be a duty to assess the social care needs of disabled children. But if we're doing that, we need to also write down when that assessment should take place. We need to identify what the threshold should be. So at the moment, the threshold for carrying out an assessment is that the child is in the area of a local authority and appears to be disabled. What local authorities say to us is if that assessment is codified in law, if we have to assess every child who might have a disability, bearing in mind there are 1.34 million of them in the country, we won't be able to meet that demand. And there's no point in assessing the needs of every disabled child because most or a proportion of them are not going to need help. It's only those with moderate to complex needs who might need help in the first place. So that's the first option, and some of the concerns that have been raised with us about what might be wrong with that option is the threshold is if the child appears to be disabled. The second option would be to tie it in, make it consistent with the threshold that applies to adults, which is any child who may have needs for care and support should be entitled to an assessment. Even then, some local authorities have said to us, well, there's still no point in us doing an assessment if it's not likely at the end of the day that they're going to get help. That's pointless for the families, it's pointless for us. So the third and fourth thresholds are tied into the likelihood of the child actually getting something at the end of the assessment. The third is a lower threshold. If it appears the child may be eligible for care and support, they should have an assessment. The fourth is a higher threshold, but they're likely to be eligible for care and support. So we need your views on which of these thresholds, or indeed whether it should be a different threshold, should apply to the assessment duty. We're also asking about parent care assessments. There is currently a legal duty to assess the needs of parent carers and request, and we are proposing to keep that, but we need to work out how it is that duty can be made effective, because what we hear from a lot of parent carers is that their needs aren't assessed. Either they don't ask for the assessment and it doesn't happen, or they are not offered the assessment and they don't know that it exists. So we need to think about why that is and what we can do about it. Moving on to the next slide, still staying within the framework or within the topic of assessments. We propose that assessments are proportionate, so that's a requirement that applies to adult social care assessments, and we say it should apply to children too. It really reflects the common sense requirement that there is no one size fits all approach to an assessment. It doesn't have to be a complex process. It doesn't always have to be a simple process. It would depend on what the child needs. A child with complex needs will obviously require something more complicated, but if something quick will do the job, for example, because the child just wants a short break to access services in the community, then there's no reason that can't happen. So the idea of putting this common sense requirement in the legislation is to reflect local authority concerns that placing an assessment duty on them as we propose would result in a very significant burden. So if we make it clear in the legislation, it's not necessarily the case that assessments will vary according to the needs of the child. They don't necessarily need to be burdensome. That might alleviate that. The next point relates to the expertise of assessors. I think one of the most oft voiced concerns we've heard from parents and carers over the last year is that those who carry out the assessments of the social care needs of disabled children don't always know about disability. So they, for example, they might be more trained in safeguarding and child protection, or if they do know about disability, they don't necessarily know about the specific disability of the child in question. So a legal requirement that the person who carries out the assessment has the skills, knowledge and competence to carry out the assessment in question and is appropriately trained is something that we are provisionally proposing. That mirrors the requirement for adults, and we think it could work for children as well. And then finally, we suggest that assessments should be combined with other relevant assessments where appropriate. So we're eager not to make local authorities duplicate work they've already done. We're eager not to make families have to retell their stories over and over. So if assessments can be combined, they should be. So most obviously, the EHC needs assessment, education, healthcare and needs assessment, and the social care assessment of a disabled child. If those two things could be combined, then they should be, so we're not having to reinvent the wheel each time. We're interested in views on whether social care assessments should be delegable. So could they be delegated to a trusted third party, for example, a charity, which might help harness the expertise of charities. That's simply one example. This is a requirement that, or sorry, this is something that can be done in the adult context. But if we are going to have the ability to delegate assessments, what safeguards are needed to make that function correctly? The next topic is eligibility. So once the assessment has been carried out, the next stage is to work out whether or not the child is eligible for services. So we're looking at disabled children's social care. The first sort of point of entry for the system is going to be that the child is disabled. How do we define disability? We know we need to move away from the definition that is in the Children Act at present. At the moment, we're using a definition which dates from the 1940s, which refers to children who are handicapped, children who are congenitally deformed, children who are blind, deaf and dumb. We obviously need to move away from that language, but without losing the broad, inclusive approach to disability that was within that definition. What we're provisionally proposing is to adopt the definition that is in the Equality Act 2010, which is the most commonly used definition of disability across government. But we think it might need some adaptations for children's social care. So at the moment, there are exclusions from the Equality Act, so that conditions that arise from addiction or conditions that manifest themselves in the form of violent, abusive behaviour, those don't constitute disabilities under the Equality Act. Those same exclusions don't currently apply to children's social care, and we don't think that they should be. We're not looking to narrow the existing definition. We don't want to end up excluding children, for example, who have conditions that, for example, who are born with addiction, children who exhibit challenging behaviour. We're not looking to exclude any children who are currently accessing services. We just want to update the language. So we're not proposing to import those definitions, but we're interested in your reflections on that. And then coming to the really important point in relation to eligibility, we think there needs to be national eligibility criteria for disabled children's social care. That was always the intention of the legislation. The key bit of legislation here is the Chronically Sick and Disabled Persons Act 1970. And when that was introduced, the idea was that there should be standardised provision across the country. So there should be a set of services which every disabled person should be able to access in every local authority. So it was meant to introduce a degree of uniformity, but that's not the way it's played out in practice. Court decision of the House of Lords in 1997 decided that local authorities should be free to take into account their own resources and design their own eligibility criteria based on their finances. So what that means is that local authorities with less money are entitled to have more stringent eligibility criteria than local authorities with more. And what that means for the children is that a child who has a certain level of need will have those needs met, or may have those needs met in one area, but if they move further down the road to another area, they may not have those needs met, even though their needs have not changed. So at the moment, eligibility is based on location rather than need. Now that is a postcode lottery, and that was recognised as early as 1998 as causing unfairness in the context of adults, because the same used to apply to adults. And so when the Care Act came into force for adults, we moved away from that local system towards a national system of eligibility criteria with uniform rules across the country. We think the same should apply to children, but we're interested in hearing your views on that, because of course uniformity across the country means sacrificing a degree of local discretion and flexibility. Now obviously all of this comes with a price tag, and so we are not dictating what we think the eligibility criteria should be. We are just saying we think there should be a uniform system, but in due course what the criteria are would need to be discussed, negotiated, co-produced between local and central government as part of a discussion about how much money is going to be put behind disabled children's social care to ensure that local authorities can meet the criteria. Because one of the things we hear repeatedly from local authorities when we talk about this is that it's not going to be possible to have a national system unless there is some change to the funding that underpins it, because the reality is some authorities cannot afford to do what others can. So that's how we think we might get round that issue. But once it's been established that the child meets the eligibility criteria, we think local authorities should continue to have a broad discretion to provide a wide range of services, whatever they think is appropriate to meet the child's needs. We're not going to be prescriptive in the legislation about what can and can't be provided. We think there should be a non-exhaustive list, but nothing more than that. So we get rid of the defined list in the 1970 Act, which says you can only do certain things. We move to a more flexible. Sorry if you lost me for a minute. I think I had problematic internet connection, but hopefully you can hear me again now. And then to be clear, one of the things we think absolutely must be provided under this single duty to meet the eligible needs of any disabled child are short breaks. Short breaks across the board are potentially the most important service that can be provided to disabled children and their families. It's often the case that families are able and are meeting their child's needs completely, but the parents, the carers themselves, are finding themselves close to breaking point or at breaking point because they need respite. So short breaks, which includes respite care as well as things like activities in the community, must be a part of the services that can and should be provided to disabled children who have eligible needs. In terms, sticking on the subject of how needs are met, direct payments are one of the ways in which needs can currently be met under the social care system. We think that those need to be kept, but that they need to work more effectively than they currently are. The two main complaints we hear about direct payments are that they aren't enough. So, for example, if a child needs a carer to go into their home to meet their personal care needs, often the rates that are paid under the direct payments to pay the carer are calculated at minimum wage, which often isn't actually enough to secure a carer. And secondly, if direct payments are made so the family can purchase services for themselves, they're not always kept under review. So if, as is often the case, families find they actually can't find anybody to spend a direct payment on, that isn't always picked up and identified. So what we're proposing is some tweaks to the direct payment system to bring it closer in line with direct payments for SEND, which are specifically direct payments must always be sufficient to meet the child's needs, and they must be kept under review to make sure that they're working. We think those rules should apply to social care for disabled children as well as SEND. We're also proposing to adopt the personal budget, which is something that parents and carers have a right to in the SEND system and that carers have a right to in the adult social care system, which is a different way of accessing services so that parents, families have autonomy, have a degree of choice over what services are going to be provided to their child, but they don't have to have the bureaucracy of managing the budget themselves. The budget can either be held and administered by a local authority or held or administered by a third party. So some of the flexibility of direct payments, but without the bureaucracy that goes with it. And then finally, codifying the existing law, we think there needs to be a legal right to care plan setting out what services children are entitled to, with, when, how, and by whom. So that's already a legal requirement, but it's one of those ones that's not clear in the legislation. We think it should be. And the same for parents and carers. If they're entitled to services, they should have a plan setting out what they are. I'm going to hand over now to my colleague Alex, who's going to talk to you about preparation for adulthood and a few other topics.
Brilliant. Thanks so much, Connor. So yes, one of the things we've heard an awful, and I should say I'm leading on the kind of transition aspect. And one of the things we've heard an awful lot about is how difficult it is in terms of making sure that young people are properly prepared for adulthood. And that's problematic in a range of different ways. For instance, that there can be situations where put very crudely, no one seems to have thought sensibly about the fact that this person is going to be a lifelong person drawing on services until the point they turn kind of 17 3/4, and then people start to panic. And there isn't the thought process which might need to go into thinking through, well, how adult services might be approaching the person may be different to how children's services were approaching the person. We've also heard in some circumstances there can be an infantilization of the young person. So in other words, a feeling that the young person needs to be protected at all costs, rather than thinking, well, this person is going to have to be supported to do things like developing the knowledge that they're going to have to take their own decisions. That's particularly difficult in the context of young people with cognitive impairments, for instance, young people with learning disability, where they aren't necessarily supported to learn that actually there's an expectation they're going to be able to make their own decisions. And then suddenly when they turn 18 and people look at them very differently, and there's no role, for instance, for parental responsibility at all post 18, a huge number of complexities arise. And so we're trying to think through, how do we make sure, and I should say one thing here on this, our terms of reference, or we've interpreted our terms of reference as applying to children and therefore adulthood starting at 18. We're extremely conscious that in the SEND context, we might be talking about people running up to the age of 25, but we're really thinking, not least because the Children Act really focuses on children under the age of 18 in terms of Section 17. We're really trying to think through, how do we make sure that what actually already exists in the Care Act in terms of starting the process of thinking about the fact that somebody may need care and may need services from social services after the age of 18, it is already there, it needs to be done. And so one of the things we're thinking is that actually, in a way, this is on the Law Commission, because the Law Commission, when it did the work leading to what became the Care Act, thought the best way of doing it was say, well, start transition planning, start thinking about the potential need to engage the Care Act post 18, start thinking at the time which is right for the child, rather than setting the right date or a fixed date. I think we've reflected on, and what we've heard so far is only really rather reinforcing the fact that probably there does need to be a specific date at which planning needs to start. What we've heard rather differing views about is what date that date should be. In health context, 14 is quite often used as an important age. I've just seen also in the chat function somebody mentioning 16, because of course that's when the Mental Capacity Act kicks in. But there may be some situations for 16 being too old, especially for somebody who may have needs which require quite a lot of complex planning to ensure that they're properly supported through into adulthood. And so we're really, really keen to get your views, either now or by way of formal consultation response, really, really keen to get views as to whether you think there should be a statutory age. So in other words, you have to have started by, or and if there is a statutory age, what that statutory age should be. We're also really important. One of the things we're thinking should happen is that for a set of principles, there should be, and this is one of the reasons to have principles, one of the reasons to have a standalone or a separate legal framework for disabled children, whether that be within the Children Act, a new part of the Children Act, or somewhere else. Part of the principles being that local authorities should always take into account the need to prepare the child for adulthood and independent living. Well, you may just think that's, as it were, motherhood and apple pie and blindingly obvious, but it is so important, and it's a situation where we're regularly hearing that it's not properly carried through, but that we think that should be placed on as strong a statutory footing as we can. So doing my best, Chris Whitty. Next slide, please, Connor. Another aspect that we're extremely keen to ramp up and beef up is participation of children. And quite a few people have already indicated to us that they really like the ideas that we're proposing in relation to participation of children. But why shouldn't these ideas apply just as much to other children, not just disabled children? And we come back to the fact that our terms of reference are making us look at specifically thinking about disabled children only. It doesn't mean that our ideas may not be equally relevant for other children. It's just that that's not what we're being asked to look at this point. And so we're wanting to think about it in two ways, and recognizing that participation, everyone already talks about, says what a brilliant idea participation is. But what we need to make sure, we think, is that that's actually carried through, so it's not just warm words. And so participation has really got two aspects to it. And I think it's important that we think about it, and we think it's important we think about them separately. The first is identifying that the child's parents and carers, obviously some parents, not all carers are parents, the child's parents and carers have very often a very, very good knowledge of the child's condition and needs, and they are the expert in the child. And the social worker and other professionals will have their own expertise, but they may not be the actual expert in that child. That could be because the child has got an unusual and idiosyncratic way of communicating, and the child's parents or carers have learned how to navigate that communication need throughout their life. That could be that's one example, but there are many other ways in which the child's parents and carers will have ways in which they can flesh out actually what the child's feeling, what the child might need. So there's that aspect, and we want to make sure that that's properly taken in account of. The other aspects, and some of you might be thinking, well, we should have started with this one first rather than second. In the consultation chapter, we start with the child first, but is the child themselves. And making sure that the child's voice is always heard. And that might be heard in one of two ways. It might be that the child is recognised as having the ability to make their own decisions about things, for instance, about requesting something. Or it might be that the child is not seen to have that ability, but nonetheless is more than able to express wishes and feelings, to use Mental Capacity Act language. And that should be taken into account. And we've really we're trying to think through a range of ways of making sure that both ways of that child's participation are taken into account. And one of the things we're thinking, and we're asking open questions about, is whether there should be some kind of statutory test to determine whether a child below the age of 16 should be able to be recognised as able to make their own decisions in the context of assessing and meeting social care needs. Once we hit 16, we think it's blindingly obvious it should be the Mental Capacity Act. But pre-16, we're thinking through, should that be the Gillick competence, or should we have some form of statutory test, which looks a bit like the functional aspect of the Mental Capacity Act. So we're probing whether the child, for instance, can understand, retain, use and weigh the relevant information. We're not looking to whether or not there's anything wrong with the child's mind or brain. It may just be that they're not old enough. But we're asking questions about if the child is able to understand, retain, use and weigh, for instance, the relevant information about what their needs are, whether that a request by the child to have their needs assessed should be seen as determinative. So we're trying to think that through. That's quite technical, that chapter, I'm afraid, but that's because the law in this area is remarkably complicated. And one of the things we're trying to think through is how to make it as straightforward as possible. Separately, we're also extremely conscious that participation is all very well, but we may well have circumstances where either the child themselves needs someone to speak up for them, or a parent or carer participating in the assessment process, but the child needs someone to speak up for them. And we want to make sure that we really think through advocacy. I think it's fair to say Conor and I don't actually necessarily interpret the law relating to advocacy in the Children Act in necessarily the same way. And the fact that two quite experienced lawyers in this area don't necessarily think the law is currently saying the same thing is probably a red flag for, at a minimum, there is a problem, that it's not clear in terms of when and under what circumstances a child can actually get a right to advocacy in the context of assessing their needs, not just making a complaint. And so at the bare minimum, we think it needs to be clarified, but we really are digging into and making provisional proposals around strengthening advocacy. We are extremely conscious, we should say, and we've heard quite a bit about this in terms of people feeding back. We're extremely conscious that advocacy, it's all very well talking about advocacy, but advocates, are a finite resource. We can't just magic them up, and not all advocates are equally good, and we need to make sure that the quality of advocacy, if advocacy is to be provided on a wider scale, is good. And so we're trying to think through, one of the things we're really looking for, and I'd really make a plea here, because I should say I'm leading on this, but I'm really making a plea for people to give us examples of good advocacy, not just situations where they're encountering advocacy which is problematic, but good advocacy, so we can work out what good is. So Connor, if I could ask for the next slide, please. We then turn to thinking through systemic issues and institutional issues, and I am slowly grinding my way through all of the local authorities in England, looking at what they're doing. I mean, actually, I'm doing two things. One, I'm looking at all their eligibility criteria, going back to Connor's earlier observation, and it's astonishing how widely variable they are. And for instance, what widely variable approaches they adopt are just even what they consider to be a disabled child, notwithstanding that actually there's a statutory definition which is out of date, but local authorities are taking very different views. But the other thing I'm doing is trying to grind through and see what local authorities are doing in terms of the law, what the law already requires, for instance, joint strategic needs assessment. In terms of working out what children are actually in their area who may need support. And it's quite striking looking at joint strategic needs assessments and also what CQC is looking at in terms of JSNAs, about the extent to which it's quite often that it's difficult to find anything actually about disabled children per se. One might find stuff relating to SEND and special educational needs provision, but actually the social care needs of disabled children is remarkably unaddressed, despite the fact there's actually arguably a legal requirement to be considering that. And so we're trying to think through how effective those tools actually are on the basis that if local authorities don't know who is in their area who might be in need of services, how can they properly plan to meet those needs? And we're also really then trying to think through how we can secure better joint working between local authorities, well, both internally actually, but also externally between local authorities and partner organisations, in particular health. One of the things we're really interested in thinking through, and bearing in mind our terms of reference are looking at social care for disabled children as opposed to either special educational needs in and of itself or health provision in and of itself. But one of the things we're really interested in trying to think through is how to make the current system work better at those interface. And we've heard quite a bit about how effective, for instance, the disco role can be. And actually, it's very nice to see. I think actually, as people are coming in, I think there's at least one disco who's on this call. So it's very nice. Thank you very much for joining. And so one of the things we're thinking about is whether provisional proposal thinking, well, should we make the disco role mandatory? And what role should the disco have in terms of being that link person, both between local authority social care and SEND, but also local authority social care and health? We can't look at healthcare, annoyingly. We'd like to, bluntly speaking for myself, I'd like to be able to look at healthcare in relation to disabled children, but our terms of reference again are looking at social care. I'm sorry, it sounds a bit like a step record, but it's important to make it clear. But what we can do is try and think through what can we do to try and make sure that there's the minimum amount of fighting, and I don't mean to use that, but I do mean to use that word actually, because actually there are situations where they're just flat out fights between social care and healthcare about who is actually responsible for a particular child. We've heard lots of examples of people working very cooperatively together, but we've also heard lots and seen lots of examples of situations where, mainly, I think, probably down to stretched budgets, people are having to really take quite hardline positions about no, they're yours, no, they're yours. And how do we make sure that that is minimised and joint working is maximised? One of the ways we're thinking about trying to do it is saying that there should be a codification of the current dividing line between healthcare and social care for children in the same way that there is for adults. I think it's fair to say one of the pushbacks we've had from at least some people is, well, that's all very well, but that doesn't actually change the position in relation to healthcare. All you're doing is identifying the line. And that's an entirely fair response. It's just the best we can do is try and identify the line to make it as clear as possible, so we can at least minimise the chances that there are disagreements about whether a child is has healthcare needs or social care needs. Next slide, please, Connor. And then the last slide from me is on remedies. those of you who have got that far in the consultation document, and I know at least some of you have got that far, will recognise that this is quite a long chapter which spends an awful lot of time describing the current position in relation to remedies. So, for instance, in relation to internal complaints procedures, in relation to complaints trying to go to local government and social care ombudsman, it's also got quite a bit about appeals to the SEND tribunal and judicial review. What it's quite light on, you may think, is, well, how should the law change? And one of the reasons it's quite light on that is that what we're really wanting is as good evidence as we can about how current remedies are actually working or not working. We've heard an awful lot and seen an awful lot of things about how current remedies don't work in different ways, but we really need to try and make sure we've got the best possible picture. One of the things we are really grappling with here as well is a disparity in the law, a clear disparity in the law between the situation where a child who is within the education, health and care provision, the SEND side, who has access to the SEND tribunal, which in last resort has the ability to direct service provision, special educational needs service provision, and also make recommendations about linked social care provision. Whereas if a child is not complaining, or the child's parents are not complaining or are not concerned about SEND, but are concerned about pure social care, their only access to a court ultimately is to the High Court by way of judicial review. And that's a very different route, and it's looking at very different things. And as a general rule, the High Court on judicial review simply won't order a public body to do something. The High Court's much more concerned about the route by which, or the method by which the decision was reached. And normally what it will then say is go away and try again, as opposed to you must. And as a law reform body, we are grappling with the fact that there is a frank disparity between the two, which is quite difficult to justify in terms of pure principle. It doesn't mean that it's not, if one simply said, for instance, well, maybe the SEND tribunal or a chamber of the health, educational, social care, a new part of the health, educational, social care chamber of the first tier tribunal should have the power to do SEND-like stuff in relation to social care. One can see that would level everybody up, but apart from anything else, it would be it'd be a massive expansion in what the SEND tribunal has to do. And many people we've also heard find the SEND tribunal an adversarial forum, and are not very happy with the SEND tribunal as a tribunal per se. And so we're trying to think through making this potential proposal. One way of resolving this would be to have the local authority, SEND tribunal, having the power to order local authorities to assess social care needs, possibly even going further than that. But we're trying to think through whether this is the right way in which to come up with that last bullet point. What we're really after, and we've got a range of proposals, and we'd really like people to be able to think things through with us or help us think things through, is what is the best way of achieving a quick, effective, accessible and independent system for resolving disputes? Because that's what people need, in particular, the speed and effectiveness. Because what we don't want to come up with, and we wouldn't want to come up with a set of proposals which, if they were implemented, would lead to a situation where people were waiting a year, for instance, to get there an all singing, all dancing form of tribunal resolution of a situation which perhaps, in fact, should have been resolved within a month. Because then that's 11 months of delay, which could be absolutely vital depending on the circumstances. So it's one of the most difficult areas we're grappling with, and we're really, really keen on getting your views both now and if you've got any space, time or energy to respond in a consultation questionnaire to that section. And over back to you now, Connor, I think.